Good day everyone, I am Naima Asali and for today I'm going to discuss the requirements of due process in criminal cases. So in due process of criminal cases, it refers to the constitutional requirements when the federal government acts in such a way that denies citizens of a life, liberty, property, interest. The person must be given notice, the opportunity to be heard, and decision by neutral decision maker. Second, what does presumption of innocence mean? The presumption of innocent mean is a legal principle that every person accused of any crime is considered innocent until proven guilty. Under the presumption of innocence, the legal burden of proof is passed to the prosecution, which must present compelling evidence to the trier of fact, a judge, or a jury. If the prosecution does not prove the charges true, the person is acquitted of the charges. The prosecution must in most cases prove that the accused is guilty beyond unreasonable doubt. If reasonable doubt remains, the accused must be acquitted. The opposite system is presumption of guilty. What is the general right to be heard? Number 1, the right to be present at the trial. It means the Sixth Amendment provides that the person accused of a crime has the right to confront a witness against him or her criminal action. This includes the right to be present at the trial, which is guaranteed by the Federal Rules of Criminal Procedure, Rule number 43. Second, the right to counsel. The right to counsel means that the defendant has a right to have the assistance of counsel, and if the defendant cannot afford a lawyer requires the government appoint one or pay the defendant's legal expenses. The right to counsel is generally regarded as a constituent of the right to a fair trial. The third one is the right to an impartial judge. Many constitutional questions resolve around the way different parts of the Constitution interact with each other. For example, the Sixth Amendment guaranteed the right to trial by an impartial jury, which is the considered part of the due process of law required by the Fifth Amendment. The next one is the right to confront witness, and the Sixth Amendment provides that a person accused of a crime has the right to confront a witness against him or her in a criminal action. This includes the right to be present at the trial, which is guaranteed by the Federal Rules of Criminal Procedure number 43. So the next one is the right to compulsory process to secure the attendance of witnesses. The Sixth Amendment guaranteed that the right of the accused to have a compulsory process of obtaining witnesses in his favor. The prosecution has the power to compel witnesses to attend using the police system at the government disposal. The compulsory process clause with the Sixth Amendment to the United States Constitution leads to criminal case defendant attend witnesses in their favor by way of a count order subpoena. The next is what is enforced to the judge by the guarantee of the right to counsel. So the right to attorney protects people from unfair trial. The success of person's trial largely depends on the ability of his or her attorney to provide an adequate defense and then to have a lawyer assistant in his defense. Even if cannot afford to pay for attorney, the Sixth Amendment give defendants the right to counsel in federal prosecution. So the next one is what does mean to be informed of the nature and the cause of the accusation. So the constitutional right to be informed of the nature of cause and accusation entitled the defendant to insist that the indictment apprised him of the crime charge with such reasonable certainty that he can make his defense and protect himself after judgment against another prosecution on the same charge. The sixth one is what is the meaning of speedy trial. So a speedy is a trial basically means that the defendant is tried for the alleged crimes within a reasonable time after being arrested. The important speedy trial is also crucial to ensure the criminal defendant receives a fair trial. If too much time depends between the alleged crime and the trial, witnesses may die or leave the area. Their memories may be fed, and physical evidence may be lost. The next is, what is a public trial? So, a public trial or open trial is a trial that open to the public. As supposed to be secret trial, it should not be confused with the show trial. The purpose of public trial is to prevent accusers in secret proceeding, which abuses may lead into oppression of accused person. The next one is, what is trial in absence and its requisites? It suffices to its state that the requisites of the valid trial is absentia. The accused has already been arraigned. He has been duly notified of his trial. His failure to appear in unjustifiable are reflected above present in the cases. So the next is, what is the writ of habeas corpus? Shall extend to all cases of illegal confinement or deportation by which a person is deprived of his liberty, by which the rightful custody of any person is withheld from the person entitled therefor. What is the proper procedure in filing the writ of habeas corpus? The family court. Petition for writ is habeas corpus. A verified petition for a writ of habeas corpus involving custody of minors shall be filed with the family court. The writ shall be enforceable within judicial region to which the family court belongs. What are the grounds for suspension of the writ? The power of suspend the privileges of the writ of habeas corpus is case of invasion, insurrection of revelation of imminent danger. Therefore, when the public safety requires it, has been launched by the Constitution, Article 9, 10, Paragraph 2.